with great pleasure too that I rise to discuss the Civil Aviation Cape Town Convention and Other Matters Amendment Bill. I too am a member of the Transport and Industrial Relations Select Committee and have been briefed on this convention. We are supporting this bill, as others have said, and it is uncontroversial, in fact. And it has a couple of purposes. One is to amend domestic legislation, and that includes both the Civil Aviation Act 1990 and the Personal Property Securities Act 1999, so that New Zealand can be party to the International Convention on Aircraft Ownership that Mr Peachy was just describing to us. And I won't go into a lot of detail about that, but just to reinforce the key points, this convention will standardise transactions involving movable property, particularly aircraft and aircraft engines, and setting down international standards for registration of ownership. It clarifies, the second part, which I'll come back to, clarifies some rather convoluted legalese in the Civil Aviation Act relating to the making of rules and who can apply them. Now, the Cape Town Convention and its associated aircraft protocol was originally negotiated under a United Nations agency, and I concur with the comments made by my colleague Darian Fenton about the importance of international conventions and the importance of New Zealand playing a lead role in them and making sure that we indeed are at the forefront of compliance with international best practice in every regard, including in employment-related matters, and certainly in relation to transport matters, as we're currently discussing. Now, essentially, this convention aims to establish a balance between enhancing creditor rights, which will, as Mr Peachy said, help to reduce aircraft financing costs, while also improving debtor protections. And it is designed to be flexible and can be applied to any type of high-value mobile equipment. The protocol that I mentioned earlier, the aircraft protocol, applies to aircraft, airframes, aircraft engines and helicopters above a minimum size or threshold. And I thought the House might be interested in getting a little more detail on that because it is, of course, fascinating. And so let me tell you that that means that it applies to aircraft which can carry at least 8 people or 2,750 kilograms of cargo, aircraft engines with thrust exceeding 1,750 pounds force or 550 horsepower, and helicopters that can carry 5 or more passengers. And the name, as probably the name gives away, the treaty resulted from a diplomatic conference held in Cape Town, South Africa in 2001. So, the mechanics of the convention, I'm sure you're now really wanting to know about that. Well, the mechanics of the convention centre on the recognition of international interests in mobile equipment and the creation of an international registry in which creditors will file these interests. And as has already been mentioned, that registry will be maintained in Ireland. The international interests are security interests in a uniquely identifiable object. And so once those international interests have been filed by a creditor, it becomes searchable in that international registry, the one that's held in Ireland, and the creditor's interest will have priority over all subsequent registered interests and unregistered interests. Now, the underlying premise is a simple one, which is that if you can reduce some of the risk to financiers in extending credit, you can reduce the financing costs for the debtor and to the industry as a whole. And currently, the problem is that currently they have to rely on differing national laws to protect their interests, and clearly they would be quite variable around the globe. In many countries, the risk factors are significant because the local laws are not that useful in protecting lenders in the event of default or bankruptcy, or are highly unpredictable. And of course, as you'd expect with an aircraft which move, this uncertainty is compounded by the fact that the aircraft can move readily between countries, and it can in fact be very difficult for the financier to know where the aircraft will be on the date of default or bankruptcy. So that uncertainty is what drives up the costs of aircraft financing, and that then is reflected in interest rates that the financier charges the debtor. So, as I said, the Convention will reduce that uncertainty and provide financiers with a number of key rights in respect to any aircraft. Now, those rights, should there be a default, to deregister the aircraft and procure its export, to take possession or control of the aircraft, or to sell or grant a lease in the aircraft, and to collect or receive income or profits arising from the management or use of the aircraft. And the extent to which those rights that I've just outlined will be a function of the declaration that we in New Zealand make at the time that we formally ratify this convention. Now, I'd like to go on and just talk about the fact that obviously with the international registry based in Ireland, as you can expect in a modern age, that will be able to be directly accessed by computer from anywhere in the world, and that will be very useful. Now, I just want to go on and talk about a couple of other matters. First of all, the flexibility into civil aviation rulemaking, the second sort of major part of this bill. The present provisions relating to the making of ordinary rules are not very straightforwardly expressed. And the bill will go on to specifies that an ordinary rule allows a matter to be determined by the authority, the director or other persons. It empowers the authority, the director or any other person to impose requirements or conditions. Now, there will be consultation requirements there, which I'm very pleased to see. I'm a great believer in consultation, and I have to say that during my short time in Parliament so far, I have been disappointed by a number of consultation provisions that we've seen, particularly around the Auckland Super City. Consultation has been a sham, and of course legislation that has reduced local democracy and corporatised, in fact, local government in Auckland has been rushed through, rammed through, in fact, by the government with a mere nod in the general direction of consultation. So I can only hope that in relation to this important matter of civil aviation rules, that the consultation requirements will be more robust. Now, I just thought I'd also talk to you about the issue of helicopters, because helicopters are indeed covered by this convention. And those that are certified to transport at least 5 person, including crew, are included in the Cape Town Convention. Now, there's a situation that's arisen in New Zealand around helicopters which is important to talk about, and that's in relation to a requirement by civil aviation which is causing some concern, and that is in the relation to helicopters that are involved in rescue helicopter work, and they now apparently have to be twin-engined because we cannot afford to have the risk of a machine crashing into a hospital. Now, I just would note that no rescue helicopter has yet crashed into a hospital in New Zealand, but just to be certain, that requirement is apparently now being put in place. And that will mean the effect of that can in fact be quite troublesome for all of those fine people involved in operating rescue helicopters in New Zealand, something that we all are proud of and reliant upon. And the upshot is that in fact in quite a few instances, single-engine machines are now having to operate away from their dedicated helipads. And that will require patients, for example, to be potentially carried by stretchers or ferried by an ambulance at a critical time. And we all know about that golden hour. I hope we all do anyway. I hope we've all had our first aid training and understand the importance of that first critical 1 hour after an accident and the need to get medical attention. And certainly any barriers to helicopters getting patients to hospitals is indeed very worrying, given that golden hour which is so essential in saving the lives of critically injured people. So we're concerned about this directive around helicopters and helipads and hospitals, and we don't think that actually it's a necessary requirement in terms of safety, and we're certainly worried about the implications for patients' health. And then, of course, there's the implications for all of those good people who raise funds for the community to get the machines that these trusts operate in it that are so important to us in a country that is not highly populated and where in fact people can be a long way from the nearest hospital. So we think we're asking the question